So welcome everyone to this webinar on this amazing book, Sex and the Supreme Court, How the Law is Upholding the Dignity of the Indian Citizen, by my friend Saurabh Kirpal, that has kindly accepted our invitation today. This webinar is organized by the Spanish Association for Interdisciplinary India Studies with the collaboration of the Embassy of India in Madrid. And we have also the support of Casa and Instituto Cervantes in New Delhi. This is Cristóbal Alvear. I'm the coordinator of law studies at the association and your host today. First, as you can see a disclaimer, this webinar is being recorded and it will be uploaded to the YouTube channel of the Spanish Association for Interdisciplinary India Studies. By continuing to be here in this webinar, you are consenting to its recording. I'm thrilled to be here today to have this conversation with Saurabh Kirpal, not only on his amazing book, but also on LGBT women and minorities' rights, among many other fascinating topics. Saurabh's career is outstanding. He has read law at Oxford University, did his master's degree at Cambridge University, and has been an advocate before the Delhi High Court and the Supreme Court of India for more than 2 decades. He has participated in several landmark cases, including the decriminalization of the so-called unnatural sex, section 377 of the Indian Penal Code. Saurabh is also set to be a justice in the Delhi High Court, the first one openly from the LGBT community. Briefly about the agenda today, we will start with introductory remarks by Mónica Fernández, Secretary of the Spanish Association for Interdisciplinary India Studies, and by Javier Parrondo, Director General of Casa. We will continue with a Q&A conversation with Saurabh, including questions from the audience at the end. So if you want to participate in the debate, please feel free to leave your questions at the chat anytime. And we will end by closing remarks by Òscar Pujol, Director of Instituto Cervantes in New Delhi. Antonia Navarro, President of the Spanish Association for Interdisciplinary India Studies, is unfortunately not joining us today, but I would also like to thank her for her standing job at the association and for her support to this webinar. Without further ado, I leave the floor to Mónica Fernández, Secretary of the Spanish Association for Interdisciplinary India Studies. We don't have the easiest name, Mónica, for her introductory remarks. And thank you so much, Mónica, for making this webinar possible.
Thank you very much, Cristóbal. I'd like to begin by thanking you all for being here. As Cristóbal has said, my name is Mónica Fernández. I am the Secretary of the Spanish Association for the Interdisciplinary Study of India. And I would also like to speak on behalf of our President, Antonia Navarro Tejero, who's not able to be here. But on her behalf, I'd like to thank you all as well. She's very grateful that this is happening. Even though I'm speaking in the name of the association, I would also paradoxically would like to thank it, because without its work and its members like Cristóbal and a lot of them who are contributing to these webinars systematically, this wouldn't be able to be happening, as well as thanks to all of our members. This association has worked for more than a decade through different academic fields to promote the study of Indian culture across the disciplines. Our members are based in very different universities from Spain, but also other countries. And we are happy to see how our association has grown and will continue to grow and organize more diverse activities that appeal to a wider range of people. I would also like to thank the Embassy of India. This is another actor without whom we would not be able to be here. And I would also like to thank the participants in today's session. We are indebted today to Javier Parrondo, the Director of Casa, and Òscar Pujol, the Director of the Instituto Cervantes in New Delhi. And of course, to Saurabh Kirpal, our speaker today. We are very, very thankful to have you here. And of course, obviously, Cristóbal, thank you very much for making this possible. So on behalf of the Spanish Association for the Interdisciplinary Study of India, I would just like to say that we are very, very happy that we are all together here sharing this moment and learning more about this book. So this is all I had to say. Thank you again.
Thank you, Mónica. Casa Asia has recognized Saurabh Kirpal with its 2022 Award on Diversity. Javier Parrondo, Director General of Casa Asia, is with us here today. I'll leave the floor now to Javier for his introductory remarks, but I want also to take advantage of this opportunity to thank him for his presence here today and for his support to this webinar.
Thank you, Cristóbal. Good morning to you all. Good afternoon if you are following us from Asia. It is a great pleasure to participate in this presentation. Although it is online, we would have loved to welcome Saurabh in Barcelona, but we will have hopefully the opportunity to do so in July, when we plan to hold the ceremony of the Casa Asia Awards. As Cristóbal has just mentioned, these awards recognize the professional background, the activism of personalities in Asia, which have make important contributions to the Spain-Asia relations, or have excelled in different fields. And this is certainly the case of Saurabh. For those of you, those of the members of the audience who are not familiar with Casa Asia, this is a public consortium. It is a unique structure because it is made up of 3 levels of the administration: central, regional, and 2 city councils, Madrid and Barcelona, which try to foster relations with Asia. It is an open window to the continent in its diversity. And has just already mentioned, we granted Saurabh the award, the Casa Asia Award 2022, in the category of diversity and sustainable development. And we did so ex aequo. He will have to share the prize with Shinta Ratri, another LGBTI activist working in Yogyakarta in Indonesia, in favor of the trans community of her city. She has been one of the first persons to put in place safe places for gathering and prayer for the Indonesian trans community. So we are very glad that the whole, or at least a large part of the persons belonging to this community are represented in this prize with Saurabh and Shinta Ratri. I would like to congratulate, of course, Saurabh for his book that we will have the opportunity to comment with Cristóbal Alvear. Saurabh has been instrumental in decriminalizing homosexuality in India. And it is a source of inspiration for us all, because as many people in Asia, well, and all over the world know, in many countries being gay or lesbian is socially acceptable, provided that is hidden and that the person in question has fulfilled what it is considered his or her social duties, such as being married or having children. So this is like a double standard that should be avoided. By the example of Saurabh, we have a reference that another way of living is possible, living your sexual orientation in liberty. So thank you, Saurabh, for your contribution in that effort. I don't want to take more time, Cristóbal. Thank you for proposing the candidacy of Saurabh to the prizes. Thank you for your support to the activities of Casa Asia, and I'm very honored to give these introductory remarks in an important event for this institution. Thank you very much from Barcelona.
Thank you very much, Javier. And finally, Saurabh Kirpal, author of the book. Welcome and thank you so much for being with us here today, and congratulations for all your late achievements.
Well, thank you very much for having me, Cristóbal, and thank you again to Casa Asia for the award and the honor that they have given to me. It's a great privilege, and there can be no better excuse or reason to come to Spain to get this award in person. Not just the food, not just the people, but now you're giving me money as well. What more could I possibly ask for?
So Raf, I would like to start this conversation by going deeper in your career to understand better what brought you to write this book. You come from a family very much related to the legal world. Your father, Bhupendranath Kirpal, was Chief Justice of Gujarat, Justice of the Supreme Court of India, and ended his career as Chief Justice of India. As I said before, you read law at Oxford, continued with your master's degree at Cambridge, and after a short period at the United Nations in Geneva, you have been an advocate before the Delhi High Court and the Supreme Court of India for more than 20 years. About your career, did your family connection with the judicial world trigger your calling as a lawyer? Why did you want to return to India and develop your professional career there? And what would you say are the main learning outcomes you have got from all these years of practice?
Well, as to why I became a lawyer, I suppose that is in the shroud of mystery as to why any child decides why they want to do what they do. It is inevitable and it is usual for your family to influence what you want to do. That's what you see around it. Growing up, I saw law around me. I was breathing law. People were talking about law. It just seemed like a natural way. But, you know, I was conflicted at one point of time whether I wanted to do law or do something else. Like any decent child, I wanted to become an astronomer, but that didn't work out. So that's why I suppose I first thought I'd start studying law, because it was what I saw around me. And then I decided that, you know, if I didn't like it, I could always do something else. You could move on, because law is, at least the study of law, is a platform that enables you to do so many other things in life. In my case, I became an author, but there's so many other things one can do really as a lawyer. But once I read law, and particularly the focus I had in university, and then in my stint with the UN when I was in Geneva, it focused me towards the social policy aspect of law. You see, while I am doing a lot of commercial law, that's where one earns money, I saw the daily impact that the law has on people's lives. And that is particularly true in India. You know, we have a long way to go in terms of the promises that were made to us in our constitution in 1950. We were a very poor country. We had a lot to accomplish. We're on that path, I think, now. But still, one very major way in fulfilling the constitutional guarantees of equality, of social justice in India was through the agency of law. You know, there's a political format that goes ahead in a particular way. But ultimately in India, the courts are so powerful that I saw changes happening through the medium of the courts. Their judgments were impacting people's lives. You can see this in the headlines of any newspaper you read in India, or if you have any interest in India. India is not like many other countries where the courts have such an outsized role in the governance of that country. And therefore, law plays a very important part of that. So if I wanted to change the country, I felt that the law or the practice of the law was something I could do. And that's why I came back eventually to India as well, because it's my motherland. It was calling out to me. This is the place where I felt I could make most change and also benefit. It's a two-way street. It's not as though I've come to redeem this country. I've come to benefit, and I'm so glad I am here. I have so much that I've gained from this place. And what have I learned? That's the third part of your tripartite question. What I've learned is to take a day at a time. That's what I've learned. You go about your practice of the law, and that's something the pandemic has also, I suppose, taught us now. Is you take it a day at a time. You have your ideals, your desires, everything in your back of your mind, but don't overthink it. Work at it, chip at it. This system was not created by me alone. it won't be changed by me alone. I am but one other mechanism to bring about change, and I will slowly do my bit. So that's why I am what I am.
And Saurabh, I've seen in your Twitter profile that you describe yourself as an accidental LGBT activist. Why accidental? What was the turning point for you?
Yeah, well, that's absolutely true. I told you since I have to put food on the table, my daily work is largely the boring commercial corporate litigation that one does. And that's what all I was doing actually for the first 10, 15 years of my career. And then came the judgment of the Supreme Court in 2013, which for the first time, I'm not going to give the trajectory of how the litigation concerning criminalization of homosexuality moved in India. I'm just going to tell you in 2013, the Supreme Court said that it was okay for a law which criminalized same-sex sexual relations or homosexuality to remain on the statute book. And when that judgment came, permitting this obnoxious provision, which had come in colonial times in 1860 and had been on our books of independent India for over 70 years, I felt angry, saying that this was a court, the Supreme Court, where I practiced. This was a constitution which I believed in, which promised equality to all its citizens, which promised dignity and autonomy to all its citizens. And in spite of the beautiful language of all the judgments I had read before, in spite of the fact that I believed in the system, if it was possible for a bench of the Supreme Court to say that they were not supposed to protect the rights of the minuscule minority, which is what the Supreme Court labeled the LGBTQIA community, it showed me how far removed the judges and the judiciary were from the realities of the daily LGBTQIA life, or indeed from the reality of daily life per se. These judges sitting in their ivory towers must be well-meaning, I'm sure, but they just did not know enough about what was happening in the country. And I felt that with all my privilege, you mentioned Cristóbal earlier, that my father was the Chief Justice of India. I came from a place of great privilege and great opportunity. And I felt that if I, with all the resources at my command, could not bring change, could not be the agent for bringing change about, then change would never happen. If I wanted to see the country change, it would have to be me who would have to go out. Someone else wouldn't do it for me. It's not a luxury we have that battles will be fought by somebody else. In India, we believe in outsourcing everything. We are the outsourcing capital of the world. But I felt that activism was not something I could outsource. So I felt that I'll start doing a little bit of activism. And the next thing I know, I got more and more and more sucked into it. I am not a full-time activist still. I still have my day job, but I try to do whatever I can. And it gives me great joy. That's all I can say.
Well, you cannot outsource judges, and now you are set to be justice in the Delhi High Court, the first one openly gay in High Court in India. It has taken sort of a while since the first recommendation happened years ago. How has your sexual orientation affected your nomination?
Well, this is something I've spoken about, that, look, this is not a done deal. Let me be clear about this. The way the system works, and I believe, since I'm part of the system, I can't question it, is that there is a recommendation by the High Court. That recommendation is then approved by the Supreme Court, and that then moves to the government, which has to approve it. If it doesn't, it sends it back to the Supreme Court. If the Supreme Court says yes once again, then the government is bound by it. So ultimately, the judges will decide one way or the other. So I'm somewhere on this process. Let's see how far or how slow it goes. My case has been unusual in as much as it has been 5 years since the first time the High Court recommended my name. And while there could be multiple causes for the delay, it was my understanding and my feeling, and I've spoken about this, is that there was certain amount of reticence that probably occurred because of my sexual orientation. I'm openly gay. It's not something I hide. And maybe that was some reason, a part of the reason as to why the delay was caused. I have reason to believe that it was in fact so. But you know what? As I said, every change takes its own time. I do not believe in revolutions. They end up doing more damage, as you with your historical background in Spain would know. So I think it's taking its own time. But I'm glad I live in a system where this can happen. It's a place where at least it's a possibility. Whether it happens or not, I do not know. As I said, I am trying to smash the glass ceiling. I might just end up banging my head on the ceiling and rupturing my head. But someone else will come after me. I believe we live in a country today which is changing so rapidly, changing so fast, that the unthinkable is becoming thinkable. I tell you, Cristóbal, 10 years ago, there were very few openly gay lawyers in India. And today, to contemplate seriously the possibility and the prospect of a gay judge is a reality. It's happening. So that discussion in itself is meaningful. Whether it happens or not, I don't know. But discussions are very important, because I find with the queer community, a lot of what happens is that we are pushed into the shadow. And I think once we bring ourselves into the mainstream and discuss it, that's half the battle won. So let's see. Watch this space.
Whatever it happens, you have already written this book, Sex and the Supreme Court, how the law is upholding the dignity of the Indian citizen, that we are discussing today. What made you start this project, Saurabh? What are the main goals behind this book?
Yes. One thing I felt, Cristóbal, always, and I still do, is that even though we have a glorious constitution and some of the most progressive laws in the world, laws are meaningless unless we have a citizenry which is informed of their rights, and it knows how you can effectively approach the courts if some of your rights are taken away. Having a right in a statute book which is hidden in some dusty library is meaningless without citizens being aware of it and exercising those rights. That's what makes the dance of democracy beautiful. So I felt that there was a startling lack of knowledge on legal rights and how the Supreme Court had interpreted the rights of the Indian citizen in the last 5-10 years, really. As I said, the Supreme Court has always been a liberal institution, but in the last 5-10 years, well, 5-10 years from when I wrote it, it gave a series of judgments which try to liberate the Indian citizen and respect her autonomy and dignity and individuality. And I felt it was important for a lot of lawyers and non-lawyers to write about their experiences about these complex legal issues in simple language for the ordinary person who could read lawyers' works without saying, is this Greek or not? I know these days, in the times of COVID, we are very concerned about Greek letters. And while in law, we use a lot of Latin and not Greek, I thought it was important that we spoke the language, an easy language, to the people who could access it. So that was the aim behind the book, to make these judgments and these laws accessible to the common person.
And to make it accessible, you have gathered different contributors with different backgrounds. So for this book, from judges and lawyers to activists and members of the LGBT community.
Absolutely.
I was just wondering how this diversity helped to shape the book.
No, I thought it was very, I don't know if you watch much Hindi cinema, but, we have these long, or at least used to have these 2.5 hour films, and you saw a very serious part of the movie, and then the audience would get tired, and then there would be a song, and then there would be a little comic scene. And frankly, while you can look down upon it, I found this a fascinating collage of putting different ideas, perspectives, ways to look at the same thing together and bring it together, right? So I'm not going to quite say that lawyers are the serious part and the activists are the comics or the songs, but no, it was important to look at certain problems which face the LGBT community, not just from the perspective of the lawyers or the judges who did a particular case, but really from the perspective of the people whose lived reality it was. I don't think, for instance, a man can truly understand ever what it means to be sexually harassed as a woman. I don't think a white person can understand what a black person goes through. So it is important, if I were to reach out to the members of the larger Indian community, for the voices of activism to get their voice and speak to the masses. So rather than having someone who is already empowered to speak on our behalf, it was important to get the activists to give their perspective on what it meant to be queer, what it meant to be a woman, what it meant to be various things in life. So that was why it was like a collage. So there are some parts of the book which are deeply philosophical. There are some parts which are very personal and heartfelt. And then the majority of the book, I would say, deals with the promise of the law. So that's how the book shaped up. And
in this book, you have written 2 chapters. The first one is on section 377 of the Indian Penal Code, criminalizing the so-called natural sex. Why do you think the criminalization of homosexual sex perpetrated in the 1860 colonial penal code stayed for so long in the Indian legal system? Were not those Victorian values in contradiction with the pre-colonial Indian principles?
Absolutely, I think that's correct. I think the history of the Indian Penal Code is really a history of colonization. This was a case of an imposition of a morality that belonged in the Abrahamic tradition of the United Kingdom in Victorian times. It had nothing to do, really, with what the law or the general perception of what India was at that point of time, I must say. Because if you go around and travel around India, you can see ancient temples and sculptures where homosexual acts are described. In my book, I talk about that while I don't think there was a great celebration of the homosexual tradition in maybe some parts of Greece it was, we did not have that in India, but there was not that hatred. There was no opprobrium. There was no, oh my God, this is the end of the world kind of stuff in matters relating to homosexuality. It was a relatively tolerant society, I would say, India. And then came 1860. Even prior to that, there was a Criminal Tribes Act in 1835. So this was really an imposition of Victorian morality, where they felt that this is a white man's burden. This is an abhorrent thing, and let us change that. But Cristóbal, that's true, and we talk about this, and that is one of the reasons it was struck down, saying that it is not our morality, it is the morality of the Victorians. The fact of the matter is that we got our constitution in 1950, and it was only in 2018, 70 years later after the constitution, that this section, which supposedly is only Victorian and not Indian, was struck down. So how did something which is foreign in nature last for 70 years on our statute books? It's easy to blame the British. It's easy to blame the Victorians. But I think we have also to introspect as to why there was this grave injustice done to the queer community. It really is a matter of injustice, and I know we'll discuss this further. And I think some part of that is the fact that like the rest of the world, the queer community was at such margins of society that it was never discussed. It was never an issue. Whenever you saw any portrayal of the queer life in cinema, it was always with giggles, people laughing, feeling awkward about it, like a joke. If it was discussed at all. I grew up not knowing any of this. I mean, for me, it was also alien. So I suppose that's why this section managed to thrive for 70 years. It was challenged only in the 90s. For the first 40 years, no one even thought that we would challenge a section of this nature. And this was in a country where we have a vibrant legal tradition where everything is challenged. You know, whatever one does, the next thing you find is challenged in courts. But for 40 years, people didn't have the courage to move the Supreme Court or the High Court. Because you must remember, when you move the High Court or the Supreme Court to challenge the section, you would like to say first that, look, I am gay and this section is affecting me. But the moment you say I am gay, you mean I'm a criminal, right? Because as long as the section stands, you say, look, Mr. Police, I am a criminal, please strike down the section. So before the court strike down the section, you've laid yourself open to prosecution. So I think that is one of the reasons as to why the section remained in our statute book, and that's how it came about. The historic, you see, I'm sorry, I'm just digressing a bit, if you'll permit me. Cristóbal, this is what we lawyers do sometimes. Is I'm not interested really as to what the history of the section was, right? I'm not the kind of person who looks at the past. The past is done and dusted. It may inform the future as one part of it, but I hope to live in the present and plan for the future. So that's why, whatever the reason for Section 377 or the anti-sodomy statutes were, it matters little. As long as it was there, it was something we had to fight. So,
and finally, it was NAS Foundation and Anjali Gopal challenged it before the Delhi High Court, and in 2009, the Delhi High Court decriminalized homosexual sex by declaring Section 377 unconstitutional. This was a landmark judgment, not only because of the outcome, but also because of the judicial argumentation used, including the right to privacy and dignity and the prevalence of constitutional morality over social morality, maybe for the first time in the Indian judicial history. Unfortunately, this judgment was later overruled by the Supreme Court. Do you think, Saurabh, that time has proven right the Delhi High Court in this judgment? Was it only mistake that maybe it was too soon, too early for the Indian judicial times?
Well, I think it was 60 years too late, to be honest, because giving justice to people can never be too soon. You know, it's often a question as to whether law changes society or society changes law. And that is a long, complex philosophical question we can discuss. But in matters relating to something as fundamental as a human's liberty to identify themselves as gay, as to give meaning to their own life, 1 second's delay is too much, right? The law should not have waited for 60 years. It's true that in the judgment, there were a lot of new, in the Delhi High Court judgment, there were a large number of new legal tools that were developed. As you mentioned, the idea of constitutional morality. Now, I don't know for the purpose of your audience what the High Court in 2009 for the first time said is that we have a constitution, and while the courts are meant to be concerned with morality, they are not meant to be concerned with the morality of the majority, because that is what fundamental rights are there for. What the courts are concerned with is constitutional morality, which is the ethos or the meaning or the spirit behind the Constitution, which in the case of the Indian Constitution is the idea of liberty, fraternity, dignity, autonomy, equality. These are beautiful words, but they have to have a meaning, you know, and the meaning is what the courts filled in really and said that this constitutional morality requires Section 377 to be struck down. And that is why I think it was late, but it's obviously very welcome. I mean, I'm not trying to say that was too soon, ever, not at all.
But as I mentioned before, this Delhi High Court judgment was overturned in 2013 by the Supreme Court in a controversial review judgment that you consider in your book an aberration. Why did this controversial judgment happen? Was this just a consequence of bad luck in the designation of judges, or the existing case law was still not strong enough to support it, or were there other influences and factors to be considered?
You know, it's a mixture of, or a cauldron of different components that came together. But I would not say it was a jurisprudence which was not sufficiently developed. I would say that this is a peculiarity of how the Supreme Court functions in India. And I'll take just a short while to explain. You know, we know of the US Supreme Court, for instance, when a case goes up, all 9 judges will sit and decide a case. In the UK or in, I think that's how it is in Spain. But in UK, for instance, of the 20 judges of the Supreme Court, 5 will sit and decide each cases. We have some 34 judges of the Supreme Court in India. And any case can be decided by 2 of them, right? So now that means you have theoretically 17 or more, actually, if you go by true mathematical regression, up to 20, 30 different combinations you can have of two judges. Now, the moment you have a possibility of just 2 out of a panel of 34 being chosen on random, you can easily see how the same institution, the Supreme Court, can give varied and absolutely contradictory and opposite results. And I think that is a failing in what happened, because our constitution says that in matters of interpretation of substantial questions of constitutional law, you must have a bench of at least 5 judges. And if 5 judges sit and had sat, this judgment which came in 2013 probably would never have come. But unfortunately, 2 judges came. I think they were very conservative judges. They were probably out of tune with what the country had become. Because, you know, from 2009 to 2013, the country changed. And again, something we can possibly discuss. So I think we had a stroke of bad luck in 2013 with the judges we had. It was not a case of the jurisprudence, because I don't think the jurisprudence had substantially changed. So.
But Saurabh, interestingly, just a few months later, in 2014, the Supreme Court granted the full range of constitutional rights, including self-determination identity, to transgender people. So what made this ruling possible? Why did transgender people succeed at that very moment in the recognition of their rights, but the rest of the LGBT community did not?
Well, you proved my point. You see, the 377 judgment came in December of 2013 with a bench of 2 judges. In January of 2014, 1 month afterwards, the judgment as relation to transgenders came with 2 separate judges. They had a completely different worldview of what rights meant, of what the idea of autonomy and dignity meant, and what they felt the role of the Supreme Court was. You see, after all, the 2013 judgment on homosexuality didn't say that it was wrong to be a homosexual or pass any moral judgment. They simply said it is not our role as a Supreme Court to come and do something about it. The 2014 judgment with the same rights gave the judges a very different worldview of what the role of the Supreme Court was. They felt that it was their role to intervene whenever the meekest, weakest person in the country is affected. And I think that is constitutionally the correct view. You see, the majority doesn't need rights, Cristóbal. They have the power of the vote. They will vote in a government and elect them. It is the weakest who need the protection of the fundamental rights. And in our constitution, and indeed in any common sense, the rights have to be meaningful only when protected. And they're protected only by the agency of the court. So the 2014 judgment had a particular vision of what rights meant and what the idea of self-determination of the transgender community was, because the judgment in 2014 decided that there would be, of course, the male and the female gender, and then there would be the so-called third gender. And not only that, the third gender would be entitled to be determined by yourself, by autonomous choice, right? You could choose your own gender. It was not incumbent on some government-appointed committee to make that decision for you. So they felt that was implicit in our constitutional rights, and they felt it was their role to protect it. So that's why these two diametrically opposite judgments came in the span of 2 months.
And talking about jurisprudence, Saurabh, in 2017, the Supreme Court finally recognized the right to privacy as a fundamental right under the right to life and personal liberty. I mean, remarkably, this very judgment establishes several mistakes in the reasoning on the right to privacy made by the Supreme Court in its 377 overturning judgment. Was this judgment a turning point for LGBT rights? Was the right to privacy the required constitutional route for the recognition of LGBT rights?
I would say that LGBTQIA rights have a much deeper and longer and surer foundation than just this 2017 judgment. So for instance, if you read the judgment which came eventually 2018, which decriminalized homosexuality, we rely on judgments not just of 2017. The historical tradition can be traced back to almost 1950, shortly after the Constitution came, in terms of the rights and the interpretation the courts gave. You know, constitutional jurisprudence, Cristóbal, does not leap. It's an incremental process. You know, it's like a sedimentary rock. So layer upon layer of shellfish give up their life at the bottom of the ocean, and then we get marble at the bottom, right? And that's how constitutional jurisprudence also works. You have a layer of precedent, slowly building up. And once in a while, we have a great event like the 2017 judgment, which will be slightly thicker layer. But that layer in turn needs to be based on something else. We don't have these superstar judgments which are divorced from the rest of the jurisprudence of the country, right? So I would say the 2013 judgment, which upheld homosexuality, was the aberration. But the 2017 judgment, which recognized the right to privacy, you must also remember, did not actually discover the right of privacy for the first time. This right to privacy had been discovered earlier in the Constitution, in the mid-90s. It was only because the government said that, look, actually the judgment of 1990s was wrong, because there was an earlier judgment which in some passing line had said there is no right to privacy. And that's why the matter came to 2017 to a larger bench. But the larger bench said that, what are you talking about? There is a right to privacy. There's always been a right to privacy in our Constitution, you see. It was not something they created. They did not pull it out like a rabbit out of the magician's hat. They interpreted the words. And that is the beauty of constitutions. It's not, it is a skeleton around which the rest of the polity is built, right? I do not believe in constitutions being only as a mechanism to curb power. Some people believe constitutions are put in place only so that there is a delineation of different branches of government, so that each branch will keep a control over the other, and separation of powers. That's one function of constitutions. I believe in a more deep meaning for constitutions, which is they imbue society with a sense of what it should be, what it can be. It is at best also aspirational, right? This is what you should be. This is what our founding fathers wanted us to be. And it gives you tools to be that. And that is what fundamental rights are. They're tools which enable you to do that. And privacy is one of those tools which is already there in the words. It just had to be spelled out. Sorry, I speak sometimes too much, Cristóbal.
Absolutely, no, I'm enjoying it very much, Saurabh. And I'm talking about the 2013 judgment. It was challenged in several creative petitions before the Supreme Court. Ritu Dalmia, the famous chef, mentions in your book how thrilled she was for being part of those hearings. What do you recall from those hearings? How did you experience addressing the court for your clients, for your community, but also for yourself in such a landmark case?
Well, Ritu is a very, very dear friend, and unfortunately, she cooks Italian food. She should really move to Spanish, I think. She's one of India's top chefs and happened to be a lesbian. And she's written in my book that when she came out as a lesbian, she went from being the nation's darling to being someone who was attacked at airports and abused, etc. And I think that's true for a large number of us in the queer community. While we have cocooned lives, there have been instances where we have felt that we have been discriminated against, when we have suffered for our sexuality. So when I argued this matter, it was, as I said, not just another case for me, right? It was as though I was arguing and asking the court to recognize me as a human being and as a citizen, as entitled to every right in this country as everybody else took for granted. I was standing up not just for the community, I was standing up for myself as well. And I suppose that made the whole hearing, which went on for several days, very, very passionate. Probably, you know, we say that a lawyer who has himself or a client has a fool as a client, has himself as a fool for a client, who represents himself as a fool for a client. And I was not technically representing myself, but I was representing my cause. But I think it was necessary, you know, for members of the queer community as lawyers to come out and argue this case. There is this big debate about how the queer community is portrayed in cinema, whether a straight person should do the role of a trans person in a movie. And there's a great school of thought which says that no, really trans people alone should act in movies, in roles of transgender people. And there is a lot to be said for that, because what I think we could portray to the court was that this was not just another dry constitutional matter, but this was a matter which related deeply to the lives of millions of people, you know. And I remember at one point, Mónica, who was another co-counsel with me, stood up and said that our lives have gone. I mean, I don't know what she was talking about. I'm not even yet 50, and she's younger than me, but still, that's what she said. She said, our lives have gone, but please give the promise to the millions who are yet to come after us. And I think that kind of a statement, that sort of realization could only come from a queer person, because we know what it means to have suffered. I'm not saying straight people cannot have empathy. Of course, you can't win battles, Cristóbal, by just queer people fighting by themselves. You know, we need allies. We need to convince the majority eventually. We need empathy. We need people with us. But there are certain areas which I think are reserved, which are deeply personal, which can be expressed by queer people in a way a straight person can't express, because you need to have experienced those things, right? I can't express to you what, as I said earlier, it means to be sexually harassed. I think a straight person probably cannot understand what it means to be a queer person. I hope to inform them. I hope to take them along, but I don't know whether they're good. So it was a great and happy experience. Sorry.
And then the really happy experience on September 6, 2019, the Supreme Court finally declared Section 377 unconstitutional. Justice Chandrachud even mentioned you in his concurrent opinion, acknowledging your role. Was it the robust judgment you were expecting? Which, in your opinion, are the main outcomes of this judgment?
I think it was everything I could have hoped for and more. You see, it was very easy for the Supreme Court to have said that, look, as you said in the 2017 judgment, in the privacy judgment, we have recognized Section 377 as being potentially violative of privacy rights. But that would have meant what? That would have meant that homosexuality is no longer a crime, because people have the freedom to indulge in sexual relationships with whoever they want in the privacy of their own homes. But I don't want to be a queer person who has a right because I'm hiding in my room. No, I want to be a queer person who wants to have the rights because I have the liberty to go out and shout that, look, I am gay, that I'm lesbian, that I'm trans, I'm intersex. So privacy as a basis for striking down homosexuality would have been a loss for me, because that would have put me back into the closet almost. Instead, this judgment comes and it is like a charter of rights. It's like the Magna Carta for the queer community. It says that the Constitution of India guarantees not only the fact that you have a right to privacy, but it gives you a positive right. It says that your sexuality is a facet of your expression and hence is covered by your freedom of expression. It is a part of your sexuality, and sexuality is part of sex. So the anti-discrimination provisions in relation to sex apply to you. And that it is part of your dignity and meaning as a person, right? So your right to life is imbued with the possibility of you choosing how you want to live your life, with which partner, and the government can do nothing about it, and the court will come and protect you. You see, it is not only a case of the judgment saying what the government cannot do. It was a case of what now the government was required to do to ensure that my right is fulfilled. For instance, Justice Nariman's judgment at the end says that a copy of this judgment must be widespread and circulated. Sorry, this was a COVID after effect. And so therefore it's a promise. And that's how I believe this judgment will now be used in more and more instances to get us more and more rights. This is just the beginning, not the end.
And Saurabh, moving to your second chapter of the book, that is about the right to marriage, you analyze two cases regarding individual choices, an interreligious marriage and an intercaste marriage. Autonomy and dignity versus the rights of community, courts versus panchayats, constitutional values versus ancient traditions. You have stated in the book that the Supreme Court has been a sentinel for individual rights and choices, but why do these legal conflicts still exist? Why have lower courts stood for the rights of the community against the rights of the individual?
Look, we cannot divorce ourselves from where we are situated. It was said, no man is an island. That's true. And all of us are very much part of the community. I know I was isolating for a few days and I know how lonely I felt. So it makes no sense to say that you have just rights as an individual and that the community has no rights. I think it's important to recognize that a community also has certain rights, and that's recognized in our constitution. So for instance, any religious right you have, right? The right to freedom of conscience, right to freedom of religion only makes sense when you're part of a community of religion, right? It's not an individual right. It is a right of the community which your part as an individual is being protected. So there will be communities and we need communities and we need to protect communities also. The question is that the moment you have communities and you have an individual, then there will be conflict. So then how do you resolve conflict? And you ask me as to why that the lower courts have not always protected the community. Well, because judges are very much a product of the same communities. A large part of legal training, and you know, when we take the oath as the superior judge of the High Court or the Supreme Court, you promise to obey the Constitution without fear or favor, affection or ill will, and you're supposed to be true only to the Constitution. And you're supposed to rise above these petty disputes between communities and individuals and see the larger picture, right? Very often that training does not happen in the lower courts. They are judges who are dealing with cases on a day-to-day basis, and they don't sometimes see as to the impact a particular case has on something other than that very case. But when you come to the higher judiciary, to the Supreme Court and to the High Court, judges have the training and have the constitutional obligation to remove themselves from that particular case and see the broader picture, right? So that is why I think by way of training and by way of the constitutional oath of office, judges of the Supreme Court and the High Court are different. And we cannot forget that, they too are products of the same society. So the same great judges who have given us these judgments are the same ilk of people who gave the 2013 judgment, right? They were also judges of the Supreme Court. They also existed. So some part of it is me as an accidental activist to go out and read books, write books. People will then read. Judges may hopefully read and change minds and hearts. But I think there has to be a symbiotic correlation between the judiciary and activists and civil society, and each helping the other to make changes and bring change about. So that's what I feel.
And Saurabh, talking about next steps and the right to marriage, the Supreme Court is hearing now the petition about same-sex marriage. So you mentioned in your book the right to companionship was already considered by the ex-Chief Justice Deepak Misra in the 377 judgment. And this judgment, intercaste and interreligious marriage, are also promising precedents on the right to marriage. How are those hearings going? Are you optimistic? As you asked yourself in your book, are the courts and society ready?
Well, this matter being heard now in the Delhi High Court just now. It may come to the Supreme Court at some point, but first it'll go to through the High Courts. Let's see what happens. I'm appearing in the case, so I suppose I should not speak too much about it, because as counsel, you feel you should not talk about a matter that you're in. But you asked me whether, and the last line of that chapter I remember in my book is that that our constitution is ready for gay marriage. The question is whether society and courts are. Well, as regards courts, I suppose we'll find out. The judgment is there. But as regards society, I'll tell you one thing. Society, especially in matters of marriage, is very conservative and traditional, right? Marriage is not just a religious thing. Marriage is so much more. Marriage is about society. Marriage is about money. Marriage is about how properties are divided. It becomes very, very vexed. So to expect society to change and accept gay marriage in a country like ours, which is a very conservative society, is difficult. But having said that, I see what has happened in Europe, and I've seen what has happened in America, is that the time lag between recognition and commencement of recognition of LGBTQIA rights, maybe some form of legal recognition of same-sex partnership and marriage, and eventually society then going behind that. Right? We have now the example most recently of Switzerland passing by almost a 67% majority the idea of same-sex marriage. My partner is Swiss, so it gives me some pride. It's very, very compressed. So I think in a decade or so, once people start recognizing and seeing change around them, once people start seeing their neighbors who are living together as friends now getting married, once they open their eyes, I think they'll open their hearts. So I'm an optimist. I think change will happen. I think we have very strong constitutional basis for the courts to recognize same-sex marriage. I mean, we have filed a case. We wouldn't have filed it if we felt we had a bad case. No one wants to file a case to lose. So I think we have a fighting chance. But the matter is in court, we'll see. But I think in the court of public opinion, I have supreme confidence. Maybe it's misplaced, but I don't think so. I think our country is changing so rapidly. We're a young country. We're a very young country. The median age of our country is about 22. And these people are not full of hatred and bias. They also have access now to the media they see around the world, which is at least a lot of the Western media that we see. in terms of Bollywood, Hollywood, and unfortunately not as much European, but certainly American. It's very LGBTQI friendly now, right? So these people are going to be the agents of change, I think, in a manner that is going to surprise us all. Not me, I said it first, but it's going to surprise a lot of people, how fast change will come.
It's so moving hearing to you talking about LGBT rights. So let's move also to other sections, chapters of the book and women's rights. That in September 2018, the same month of the 377 judgment, the Supreme Court decriminalized adultery, considering it unconstitutional, discriminatory, and retrograde. And in the controversial case on the access to the Sabarimala temple by women, stated that any exception placed on women because of biological differences violates the Constitution. Both cases are discussed in your book. Are women's rights at the forefront of an anti-patriarchal legal struggle? Do other minorities benefit from intersectionality with the advancement of women's rights and vice versa?
I think the protection of any individual rights is the protection of everybody's rights. There is no greater way to ensure freedom than to fight for everybody's rights. And there is no greater way to ensure dictatorship than to allow someone else's rights to slip, right? I think it's so obvious that if today we have a system where one person's rights can be taken away, tomorrow everybody's rights can be taken away. We're using the very same system against yourself. So women's rights, while, as I said, are peculiar to women, of course, but they flow from the same constitution. They have the same words. The right to the LGBTQI community flows from Article 14, equality guarantees. The right to the Dalits, the lower castes in India, to the religious minorities, to all kinds of communities flow from the same liberating words. It is a representation after all, Cristóbal. A right is not just a right per se in that individual which inheres. That right is it's actually an aspiration, as I said earlier, of what kind of country we want to be, right? Is it a country that allows freedom to flourish? And when we recognize a woman's right and we recognize her dignity and her autonomy, and we recognize the fact that you can't stop a woman from entering a temple just because she's menstruating, right? We say we are a certain kind of a country. We say we're a kind of a country. We will not look back into old age superstitions. We will not be the kind of country that permits hatred. We will not be the kind of country that allows small-mindedness. We do not want to be the kind of country which allows discrimination on antiquated basis. So the moment we say we are that kind of country and we uphold rights for one class of citizens, the same ideology will then go on and protect everybody else in every other kind of a minority, and ultimately not just minority. This is not just what kind of country you want to be, Cristóbal, is not a matter that is restricted to a minority. That is a fundamental issue of what the majority wants to be. I dare say that the vast majority of my country does not want to be a country which is known for discriminating against women. So you may have instances of discrimination, and when you stand up and you win those instances of discrimination, then I think it is a win for the majority as well as the minority. So I believe in intersectionality firmly. You cannot parcel, cherry pick different rights as belonging only to some people, because every time I say this right belongs to you, there's inevitably an implication that the same right does not belong to someone else. You got something special, that means someone else does not have it. No, that's not how rights work. Rights work only when everyone has every right, right?
And Saurabh, talking about the majority, the Supreme Court has positioned itself as a contra-majoritarian institution devoted to granting fundamental rights to minorities and minorized groups. In many cases, the common legal path for right-related issues starts with case law and then legislation follows, as it happens, for example, with transgender rights. Do you see Supreme Court as a counter-majoritarian institution? What are the main threats that might jeopardize this role?
Well, I certainly see the Supreme Court as a counter-majoritarian institution, right? I think one thing we must do is, with our written constitutions and our now fairly well-established legal structure, is to distinguish democracy and majoritarianism, right? I love to live in a democracy. One facet of democracy is elections where the majority wins. Another facet of democracy is that I must be allowed to live a full, free, meaningful life without the fear of the majority, so that one day I may become part of the majority, or one day I may choose not to become part of the majority. Democracy is so much more. Democracy to me is a system which permits every individual in themselves to accomplish all that life has to offer. And there are different systems sort of approaching and getting that done. In the system that we have chosen in India is we have majoritarianism, which is enshrined by the conduct of free and fair elections on a regular basis. But we recognize that the majority, as I said to you earlier, will oppress minorities. That's what powerful people do. Hell, that's what patriarchy is all about, right? For ever since a penis has existed, men have tried to subjugate women. So it's that's what happens. And therefore, to protect the rights of the less powerful, we need to have an institution like the court, which will stand up to the majority and say that, you know, it is this very majority that gave us this constitution. And we must not forget that, right? After all, the constitution is not something that was just dropped out of nowhere. It's part of, and it has a legitimacy of the majority community, right? So if you, Mr. Majority, believe in the constitution, then you must also believe in the promise it holds in individual rights, even if it means going contrary to the majority, right? So paradoxically, the act of protecting a minority right is in fact a fulfillment of a hidden desire of the majority to protect its constitution. So it's counter-majoritarian, but I can see you looking anxious just now, Cristóbal, so I'm going to shut up.
I had a problem with my mic, so I couldn't hear what you said. I will have to go back to the video whenever it's uploaded to YouTube. So, so that just to end with my questions, Justice Chandrachud stated, and you have written here in the book, that the Constitution of India has within it the ability to produce social catharsis. Do you think that law changed society? Do law outpace society? Do constitution make the way, the path to change society?
Well, yes. I think it is, what is a constitution if not something, as I said repeatedly, a charter of the best that we wish to be. You know, constitutions are framed typically, Cristóbal, in times of the nation's birth, when typically there is idealism all around. You know, whenever a country becomes free and it comes out of the constitution, you're full of all the good things you want to be, right? And it's like a New Year's resolution. Every year I say, this is the year I'm going to drink less, I'm going to work out more, I'm going to lose weight. But the constitution embodies those ideals and ultimately provides a mechanism to ensure that those ideals are then fructified. So yes, in a country like India, where we are deeply, deeply conservative, where I cannot rely on majorities to change the laws, where, because for instance, 377 would never have been undone by Parliament, because it was not an issue, because we do not, after 75 years of our existence, have an anti-discrimination law. Can you imagine that? You can discriminate on the ground of sex, sexuality, religion, caste in India by the private sector. There's no law prohibiting it. So I don't always have hope for Parliament. I'm not a cynic, but I don't have hope on these matters of rights. At that point of time, the Constitution has to be relied on to use the guarantees that it provides. And it's a democratic thing. I mean, ultimately, that Constitution recognized that there will be instances when the majority will fail. And that's why we can rely on the courts to protect the Constitution. Because ultimately, we are not a government of law or men. We're a government under, or indeed women. Or indeed the third gender. We're a country governed by the Constitution. And to be the best we can possibly hope to be. So yes, the Constitution is cathartic. It provides for a happy reading. But I think we've lost you, Cristóbal. You're on mute.
It has been a wonderful conversation, Saurabh. Thank you so much. Let's check. We have a question at the chat that I think you can also check.
There are no questions, Cristóbal, because I answered every possible question that could possibly arise.
There
is nothing
many.
left. Or else I was so boring that no one could say anything.
It's Marlene stated, my question to Saurabh would be, in what way you can make a difference in the way you rule about law in terms of recognizing rights of minorities compared to conservative judges? What space does the legal system give you in the Rollins for bringing about change in recognizing and advancing the rights of sexual discriminated persons?
Yes. Will you just excuse me for a second? I'm going to put the light on because I did not know it will go on so late. So just 1 second.
Absolutely. And if anyone
well,
wants
let's see. I'm back.
Okay.
It's the light switch is close by. No, I think one instance of what I believe how the law can bring about change in ending discrimination is one chapter, for instance, which is written in my book on the Me Too movement. And one very famous judgment of the Supreme Court of India in the case of Vishakha, which is sexual harassment at the workplace. India, as I said, has no anti-discrimination law. And I do not understand why we do not have it. It would be politically one of the best things for any government to do it, because after all, if you stop discrimination against women, you are helping 50% of the population of electoral votes. But I think it just has not entered the public consciousness to discuss this. But since that had not happened, in 1997, the Supreme Court held that any person, any woman working in a private establishment had a right to be able to work with freedom from fear of sexual harassment. And even though India did not have any law which prevented sexual harassment, the court said that because the Constitution guarantees you the right to a meaningful life, and since you cannot exercise that right to meaningful life without being able to work, without being harassed at your workplace, we will step in as the court and lay down guidelines and say as to how committees will be constituted and how complaints in relation to harassment will be met. And so that was one very clear case of how the law has stepped in and allowed for matters where discrimination is faced by a particular community.
And I have received one more question on the next legal steps for the LGBTQ community and beyond same-sex marriage. What are the other steps that the community may need to take?
Oh, I believe same-sex marriage is one of the easier, shinier objects. You know, we all get sometimes distracted with the big shiny objects. And I recognize that same-sex marriage is very important to me and to a lot of other people, but it's not going to transform the daily lives that the queer community faces in India. And I think for that, the most important thing is to ensure, as I said earlier, an anti-discrimination law. Now, the parliament, I repeat, is not going to frame any anti-discrimination law. We will have to go to court on a case-to-case basis on every time any form of discrimination is faced by a member of the queer community. So, for instance, if even though the law technically permits you to open a bank account with your partner, you are prohibited from doing so, move to court. If you are fired from a job because you are a member of the queer community, frankly, there's nothing you can do about it. And even the Constitution, now you must remember the Constitution only gives you rights against the government, against the state. But you will have to try to develop a body of jurisprudence which says, like in Vishakha, like in the case of sexual harassment, that if I am not allowed to work at my place of choice, live at my place of choice without fear of discrimination, my life is going to be meaningless. And hence I'm demeaned and denuded of my autonomy and dignity. And therefore, there is an obligation on the state to ensure that I am not diminished as a human being. The court will then step in, hopefully, and lay down its own form of anti-discrimination law, right? So I think that's what the next step for the queer community really is, more than gay marriage, is the right to be able to work without fear, the right to be able to get medical treatment, right to be able to enter a public place without any of these fears, right? So we need that. That's what we truly, truly need. And I think the most important community in the LGBTQIA community, really, and we do not talk about it enough, is the trans community. I think if there is a caste system within the members of minority sexuality, it would be the trans community. And we have a transgender bill. It's been challenged in the Transgender Act now. It's been challenged in the Supreme Court. We need to stand up for trans rights in a much greater way than we have so far. That's what I believe.
And Saurabh, one more question on reparation of the harm suffered. So Justice Indu Malhotra stated in her concurrent opinion on the 2018 decriminalization judgment that history owes an apology to the LGBT community. What is the apology that the community expects? How can all this suffering be repaired?
Well, I could be very magnanimous and say, no, let bygones be bygones, but I am not quite so magnanimous. I expect reparations. I expect, and what are reparations? One example is, for the trans community, for instance, is because of the historical injustices done to the Dalits, to the scheduled caste, to the untouchables, as you probably know them, in India, we have a promise of reservations in the future, right? So because of the past injustice, reparations in the future to bring you up to level in the form of reservations are foreseen. So I would say the same thing. For the trans community, the Supreme Court judgment of 2014 said that there must be reservations in public employment for the trans community. The Transgender Act does not provide for any such reservation. So I think that, there is no point saying sorry and moving on with their life. That's too cheap. I want more payment than that. I don't want your pound of flesh. I want my pound of flesh back to me, which you took over the years, right? So I want the apology, and I want a lot more. I want to have extra, well, people say extra things, right? You are not starting off on a level playing field. And when as a queer community, you're not starting off on a level playing field, you every time give them something which is perceived to be extra is not extra at all. It's really doing exactly what Justice Malhotra said, which is apologizing in actions and not words.
And I think we have time for one more question on civil society activism. So these landmark cases have been accomplished thanks to the commitment of public figures, the legal activism of civil society, or the participation of committed lawyers like you. Do you think that the involvement of the civil society was a game changer?
Undoubtedly. You see, people like me just came and almost took the cream when the hard work had really been done by members of civil society. This fight in India did not begin with me. It began in the 70s. It began, we always forget the effort of all the people who come before us. And no doubt in 20 years, people will not remember who I am. And in 30 years, they'll not remember you are, Cristóbal, because you're 10 years younger than I am. But I don't forget that. I think we would not today be in the position where we are without members of civil society having sensitized society at large. And also very specifically, the 2009 judgment was delivered by Justice A.P. Shah and Justice Muralidhar. And I know how legal seminars had been held much earlier in advance by other lawyers and activists when Justice Shah was in the High Court in Bombay, trying to engender a sense of awareness of the community, right? And that ultimately paid off in the 2009 judgment. So no person will accomplish change themselves. And I certainly don't believe that I have been anything greater than a simple vessel or a right person at the right time to be able to have done this case. I don't have that kind of ego. I don't think so. And I think if I were, then change would not happen. So civil society has a great, great role. But I would also say is that let's not diminish the role of the lawyers. And everyone likes to talk about lawyers. There's a very famous quote of Henry in Shakespeare. He says, the first thing let's do, let's kill all the lawyers. But let's not do that. Lawyers have also put in their work. I think the time has come for the community to be a little less fragmented, try to be more united. And one way we will unite ourselves is to be open in our hearts, to recognize the input that every other part of the movement has done. We could not have reached where we have today without lots and lots of people, named and unnamed. And I say my thanks to all of them, right? So
thank you, Saurabh, for such an inspiring conversation, and thank you all for your contributions to this Q&A. So this webinar was supposed to be held at Instituto Cervantes in New Delhi, but unfortunately, due to the COVID restrictions, we had to change it to an online version. In any case, I would like to thank Òscar Pujol, Director of Instituto Cervantes in New Delhi, for his kind offer and for being with us today. Òscar, the floor is yours for your concluding remarks.
Thanks, Cristóbal, and thanks, Saurabh. It's been really a very rich discussion with so many points. And if I have 5 minutes, I will like to comment on a few of them, to close this. First of all, you are an accidental activist, which I think is a very nice definition, but an accidental activist that believes that activism should not be outsourced in a country like India. And yourself, you define yourself as, you think that you are not a revolutionary, being a judge, that makes quite a lot of sense. And you believe in the possibility of reform. In fact, it struck me, when you said that you believe there is a symbiotic relation between the judiciary and activism. This is not a thing, that comes often to our mind when we tend to see the judiciary sometimes as opposed to activism, which I think it's a very interesting. And you also put forward a notion of the Constitution, which I find, very liberating, because you said that Constitution is not there to carve powers, not to set limits of what we have to do or we cannot do, but Constitution should be inspirational. That's great. It should really, embody a kind of aspiration in upholding the liberty, dignity, and equality, which is the soul of Constitution. And you said also, that laws are meaningless unless we have a citizenship that knows how to uphold their rights. And I think, that's what you try to do in your book, to make the laws and judgments accessible to the common man, which is a beautiful thing, because as you know, we are not lawyers, and sometimes we really get lost, in that jargon of laws and rights. You see, Saurabh, as I see you, and you said it very clearly also by the end, I see you as another rung on the ladder of hope. And this is a ladder of hope, which grows taller and taller by the day. And let me tell one thing, that comes really from my own experience. You see, I come from a country, Spain, and when I was a kid in this country, homosexuals were really persecuted. Homosexuals at that time, they were confined in work establishments and agricultural colonies. They were subject, to work under inhuman conditions until they felt exhausted and suffered beatings and corporal punishment and hunger. More than 5,000 people were arrested for having homosexual activity during Franco regime. And don't think that India is lagging behind. Even in the 70s, there was a new law still under the dictatorship of Franco, when it was more human than the one that was before, that were confining them in really concentration camps. But under this law, the focus was on treating and curing homosexuality. And 2 prisons were established in Spain at that time. And in these establishments, they tried to change the sexual orientation of the prisoners through aversion therapy. That's to say, they gave an homosexual stimuli and electric shocks were given. After, they gave an heterosexual stimuli, and then the electroshocks were, stopped. I am saying that because I am a believer in hope, because that same country, Spain, has become the 3rd country in the world to legalize same-sex marriage in 2003, after the Netherlands and after Belgium. So you say, I was a kid when these things were happening, and I am already now in my 60s, over my 60s, and we can say that about Spain. No? So I think India, and I am an optimist like you, if a country like Spain has done that in less than 60 years, I'm sure that India would do a lot more, and the same-sex marriage will be already legalized, and the conditions will keep improving. Thanks very much for such an inspirational talk, and hope to see you.
Thank you very much, Òscar, for your kind words, for your time, for your availability, and thanks also to Saurabh for sharing with us his time as his wisdom today. Today we have discovered that judicial battles for granting fundamental rights are worthy to be encountered, that civil society activism is key to change the social narrative, that law can outpace society, that intersectionality is key for the advancement of the rights of minorized groups and minorities, that the Constitution of India has the ability to produce social catharsis, and that the law is upholding the dignity of the Indian citizen. You want to go further on these topics? The book is available online, both hard copy and ebook versions. And Saurabh, I would like to share, if you would like to share any closing remarks, the floor is yours.
Nothing. I just noticed that there are 13 people left now, and I wonder who's Judas and who's Jesus. The book is available. Yes, please do get it. It'll be out in paperback soon. And more than that, Cristóbal, maybe I'll speak to you later about translating it into Spanish. But more than that, I think if we want change to happen in India, I need to write in the vernacular, because India is still not just about English. It's so much more. But thank you for all of you on a Friday afternoon to sit here and hear me drone on and on and on. I hope I wasn't too boring. And if you are so excited, see it again. It's on YouTube. Thanks.
Thank you. Of course, Saurabh, India is about diversity, and that's what we love India. And we are going to finish here this webinar. It will be available soon at the web of the Spanish Association for Interdisciplinary Studies of India. Next one is in 5 days, on February 23rd at 5 p.m. Or Madrid time, or 9:30 p.m. Indian Standard Time, on activism patterns of the Indian American diaspora. Stay tuned to our social media for more info. Before ending, I would like to thank the Spanish Association for Interdisciplinary Study of India for organizing this webinar. Thank you, Mónica, Luz, and Jairo, for your outstanding work. Our gratitude to the Embassy of India in Madrid, without whose collaboration this webinar would not have been possible. Thanks to Casa, to Cervantes for supporting us today to spread this webinar. Thank you so much, Saurabh, for this inspiring and amazing conversation. And thank you all for attending this seminar today. Have a great weekend.
Great weekend, everybody.